Welcome to JAIIB Mock Test Series. In this video, we will be solving various questions of legal and regulatory aspects of banking with detailed answer explanations. You can also log into our website or download mobile apps to explore more than 4,500 mock test questions, including previous year's question papers. You can access full-length mock tests, chapter-wise, practice question sets with detailed explanation and download chapter-wise study material. So let's get started.
Which of the following is not a part of public sector banks? State Bank of India, regional rural banks, nationalized bank, or none of the above? What is your answer? Of course, it's a none of the above, because public sector banks are banks where a majority of a stake, that is more than 50%, right, is held by a government. The share of these banks are listed on a stock exchange. There are total of 21 PSBs in India, since SBI, nationalized bank, regional rural banks are part of the public sector banks. Correct? Question number 2. Under Section 22 of Banking Regulation Act 1949, commencing or carrying on of banking business without a valid banking license from RBI is permitted, can be got regulated from RBI, is prohibited, or can be continued where it has been cancelled and the liabilities towards the depositor have not been discharged. इनमें से कौन आंसर सही है? Yes, is prohibited. Under the section of 22 of BR Act, commencing or carrying of any business without a valid license from RBI is prohibited. क्योंकि कोई भी कंपनी तब तक बैंकिंग बिजनेस नहीं कर सकती है जब तक वो आरबीआई से सर्टिफिकेट नहीं ले ले रजिस्ट्रेशन के लिए, बैंकिंग रजिस्ट्रेशन के लिए. करेक्ट? Question number 3. If an Indian bank has place of business in more than one state and no office in Mumbai or Kolkata, then what is the amount of minimum capital required? Your answer is 1 lakhs, 2 lakhs, 5 lakhs and 10 lakhs. क्या है आपका आंसर? सही, इट्स 5 lakhs. क्यों? क्योंकि as per section 11 of BR Act 1949, the requirement as to minimum paid up capital and reserve, if it has places of business in more than one state and no office in Mumbai or Kolkata, then it is 5 lakhs of rupees minimum capital requirement. Great. Got it? Now move on to next questions. Question number 4. Under section 36AA, who among the following cannot be removed from a bank by RBI? सेक्शन 36AA के अनुसार इनमें से कौन से बैंक के एम्प्लॉय हैं जो आरबीआई जिनको रिमूव नहीं कर सकता है? ऑप्शन 1 इज चेयरमैन, ऑप्शन 2 इज डायरेक्टर एंड ऑप्शन 3 इज चीफ एग्जीक्यूटिव ऑफिसर एंड द लास्ट ऑप्शन इज नन ऑफ द एवर. And the answer is none of the above. क्यों? As per 36AA of BR Act, to remove any chairman, director, chief executive officer or other officer or employee of a banking company RBI has been empowered to remove. But the condition is the bank has to satisfy that it is necessary to do so. What is the purpose to maintain cash reserve for CR purpose? Question है कि what is the purpose to maintain cash reserve for CR purpose? Option 1 is balance in currency chest. Okay. The second is cash in hand. Third is balance with other banks. And the fourth one is cash deposit with RBI for this purpose. Yes, answer 4 is correct one. Cash deposit with RBI for this purpose. क्यों? क्योंकि cash reserve ratio, which is a CRR, is the amount of cash that the bank have to keep with RBI. They have to maintain a certain percentage of their deposit in the form of cash and can use only the remaining amount for lending and investment purpose. Okay. Question number 6. The undertaking of an acquired bank may vest in the central government or in any company or corporation as directed by the central government is true or false, or partly true, or cannot say. What is your answer? Yes, it's false. Why? Because the undertaking of an acquired bank may vest in central government or any company or corporation as directed by Reserve Bank. Okay? And not by central government. It's a job of RBI. Question number 7. The share capital of RRBs is held by, क्वेश्चन समझ लें, शेयर कैपिटल जो होते हैं आरआरबीज के, वो किन के पास होते हैं? वो स्पॉन्सर बैंक के पास होते हैं, सेंट्रल गवर्नमेंट के पास होते हैं और स्टेट गवर्नमेंट के पास होते हैं, या किसी के पास नहीं होते हैं? यस, योर आंसर इज करेक्ट. इट्स स्टेट गवर्नमेंट. क्यों? क्योंकि रीजनल रूरल बैंक्स आर लोकल लेवल banking organization operating in different states of India, and they have been created with a view to serve primarily to rural areas of India with basic banking and financial services. लेकिन RRBs may have branches set up for urban operation and their area of operation may include urban areas too. ऐसा नहीं है कि सिर्फ गांव में ही कर लेंगे, रूरल बैंक है तो सिर्फ गांव में ही ऑपरेट करेंगे, वो शहर में भी कर सकते हैं. और इनका जो शेयर कैपिटल होता है वो स्टेट गवर्नमेंट के पास ही होता है. On which of the following a collecting bank will get protection under section 131 of Negotiable Instrument Act? Crossed draft, crossed promissory note, crossed bill of exchange, or cross check? Yes, the correct option is fourth one, cross check. Section 131 of Negotiable Instrument Act provides protection to collecting bankers who receive payment of a cross check on behalf of his customer, and not for cross draft and cross promissory note or cross bill of exchange. Got it? Great. Number 9. A collecting bank gets protection under section 131 of Negotiable Instrument Act only if option 1 is collection is in good faith and without negligence. Option 2, the bank collects only on the behalf of customer. Option 3, the bank collects only cross check. Option 4, all of the above correct. That is A to C. Why? Because the section of 131 of the Negotiable Instrument Act affords statutory protection in such a case where the customer's title to check which the banker has collected has been questioned. Then only section 131 comes into the picture. Okay, great, got it. Let's move on to Next questions, that is question number 10. Question number 10. In a bill of lading, the specified goods have been consigned to the named person. Such kind of bill of lading is called what? Short bill of lading, consigned bill of lading, straight bill of lading, clauses bill of lading. The correct answer is straight bill of lading. Why? Because a straight bill of lading is generally accepted to be one that makes the good deliverable to a named consignee and either contain no words importing transferability or contains words negating transferability such as non-transferable.